So today I want us to shift our attention to homicide. And in this video, we are going to focus predominantly on murder, the elements of murder, and the actors' reuse of murder. Now, what is homicide? Homicide is the killing of a human being by another human being. And the important principle to remember as far as homicide is concerned is that all killing is homicide, but not all homicide is unlawful. So we have two types of homicide. We have number one, the lawful type of homicide. And lawful homicide occurs where killing is legally justified. And examples include, execution or advancement of justice. We also have reasonable defense of person or property, and we also have accident or misadventure. We have the second type of homicide, which is unlawful homicide, and this includes murder, it includes manslaughter, it includes suicide and infanticide. And the main examinable unlawful homicides are usually murder and manslaughter as governed by the penal code, especially in Kenya. So I want us to start with murder as one of the unlawful homicide. So what is murder? So murder is the unlawful killing of a person with malice aforethought. And this is according to section 203 of the penal code. So the elements of murder include a number of things. So that for murder to exist, the prosecution must prove about four things. They must prove there was death of a person that was caused by an unlawful act or omission with malice aforethought, and that death occurred within a year and a day of the act. So I want us to look at the actus rea of murder. So the actus rea of murder consists of two things. It consists of the act or omission and also the consequence, which is death. So that there must be causation between the accused conduct and the death. And that means proof of death is critical when it comes to murder. And death must be proved through a number of things. The first way death can be proved is through medical evidence. And here we usually need a post-mortem report, but it can also be proved through eyewitness testimony. Or thirdly, it can also be proved through circumstantial evidence, especially if the body is missing. So that the failure to prove death is an equivalent of an acquittal. That means the accused is going to be released. Now, there is the case of Yohana Lubowa versus Regiman 1953. And the facts of this particular case were that the deceased died in hospital after being attacked. And evidence regarding admission, treatment, and time of death was required. And so the issue was, must hospital treatment details be provided where death occurs after admission? And the rule is that where death occurs in hospital after injury, prosecution must provide a number of things. They must provide admission evidence, they must provide treatment details, and they must also provide the time and cause of death. And the analysis of this particular case was that the failure to explain medical treatment weakens causation connection between injury and death. And the conclusion of this particular case was that the medical evidence connecting injury to death is very essential. We also have the case of Rex versus Serasi Bachumira of 1936. And the facts of this particular case were that the accused stabbed a person Now, 7 days later, someone with a similar name died in hospital. No identification linked the two individuals. And so the issue was whether the proof of death and identity of the deceased is necessary. And the rule is that the prosecution must prove a number of things. They must prove, number one, death occurred. They must also prove the identity of the deceased. And they also have to link the accused act and the death of the deceased. And the analysis of this particular case was that no evidence connected stabbing victim to the hospital patient. So the conclusion of this case was that the conviction was quashed for lack of proof of death. Now, we also have another case of Kimweri versus Republic of 1968. And the facts of this particular case were that the accused was charged with murdering his wife after disappearance, and no body was recovered. And a letter later suggested accidental death. And the issue in this particular case was, can death be proved through circumstantial evidence alone? And the rule is that circumstantial evidence must, number one, compel inference of death, and secondly, exclude possibility that the victim is actually alive. And the analysis of this particular case was that the evidence did not conclusively prove death. And the conclusion of this case was that the conviction was quashed. We also have the case of Rex versus King'ori wa Gakuha of 1946. And the facts of this particular case was that the accused beat the deceased with sticks. And medical evidence showed death resulted from strangulation. And so the issue was, must cause of death match accused act? And the rule is that the cause of death must be linked to the accused conduct. And so the analysis of this particular case was that there was no proof that the accused strangled the victim. So the conclusion of the case was that the murder conviction was reduced to assault, occasioning actual bodily harm. The other case is the case of Republic versus Chair and another. And the facts of this particular case were that there was no post-mortem produced. And so the prosecution relied on eyewitness testimony. And so the issue in this particular case was, can death be proved without medical evidence? And the rule is that death and cause of death may be proved through non-medical evidence. And the analysis of this particular case was that the eyewitness evidence was actually sufficient. The conclusion of the case was that the medical evidence is not always mandatory. Now, we also have the idea of possession in murder when it comes to the actor's wish in murder, and this is covered under Section 213 of the Penal Code. So that a person causes death even if their act is not the immediate cause. And such situations include, number one, death during medical treatment. So that the accused is liable if injury leads to treatment and then the treatment leads to death, unless now the treatment is grossly negligent. If you look at the case of Rex versus Mwagambo, son of Gishodi of 1941, the facts of this particular case were that the accused inflicted deep wounds on the victim. And so the medical dresser stitched the wounds instead of draining the wounds. And so the deceased died from what we call sepsis. And so the issue in this case was, did medical treatment break the chain of causation? And the rule is that improper treatment does not break the chain of causation unless it is negligent. And so the analysis of this particular case was that the risk of sepsis existed regardless of the method of treatment. And so the conclusion of the case was that the accused was held liable for murder. Now, the second situation also involves failure to seek medical treatment, so that the accused is still liable even if victim refuses treatment. If you look at the case of Tindira, son of Chiru versus Rex of 1951, the facts of this particular case were that two accused persons struck the disease with sticks, causing skull fractures. And the issue was, is the accused liable where the victim fails to obtain treatment? And the rule was that the accused is liable if the injury contributed to death despite the absence of treatment. And so the analysis of this particular case was that both injuries contributed to the death of the deceased. And the conclusion of this case was that liability was actually established. We also have the third scenario where the victim takes evasive action and dies. And a good example is where you have a victim jumping from a building while trying to escape an attack. So the accused is still liable if the reaction by the victim is reasonable. And we also have another scenario, the fourth scenario, where the accused hastens the death of the sick person. So that in this particular case, the accused is liable where the victim is already weak or injured. If you look at the case of Rex versus Okute, son of Kaliebi of 1941, the facts of this particular case was that the victim was beaten twice. And the second beating accelerated death. And so the issue in this particular case was, is acceleration of death sufficient for liability? And the rule is that hastening death amounts to causing death. And so the analysis of the case was that the second beating by the accused worsened the condition of the victim. And so the conclusion of the case was that the accused was found guilty of murder. We also have the fifth scenario where death is caused by combined acts. So that where death results from, for example, the accused act plus the victim's act, or the accused act plus another person's act, then the accused is still liable. And here we have the case of Tindira, son of Chiru versus Rex of 1951. And the facts of this particular case were that two attackers inflicted separate skull fractures on the victim. And so the issue was, can both attackers be liable? And the rule is that a person causes death even if their act alone is insufficient. And so the analysis of this particular case was that the first injury contributed to the fatal outcome. And so the conclusion of the case was that the second accused was liable under causation principles. We also have under actus reus of murder the idea of possession through circumstantial evidence. And here we have the case of Ndunguri versus Republic of 2001. And the facts of this particular case were that the accused was the last person to be seen with the deceased. And so the body of the victim was later found in the accused latrine. And so the issue in this particular case was, can circumstantial evidence prove murder? And the rule is that circumstantial evidence must connect the accused to death and exclude alternative explanations and options. And the analysis of this particular case was that the accused failed to explain separation from the deceased. And so the conclusion was, the conviction was upheld by the court. We also have the case of Rex versus Israeli Epuku, son of Acheutu of 1934. And the facts of this particular case were that the conviction was based purely on suspicion. And so the issue was, is suspicion sufficient for conviction? And the rule is that suspicion alone is actually insufficient, so that evidence must conclusively connect the accused to the death. And the analysis of this particular case was that the evidence was actually incomplete. And so the conclusion of the case was that the conviction was unsafe. So that is all as far as murder and the accessory of murder are concerned. But maybe to provide us with a summary, we have said that to prove murder, the prosecution must show a number of things. They must show that death occurred. They must show that there was the identity of the deceased. And they also have to show the cause of death. And they must also prove, the unlawful act or the omission that caused death. They also have to prove malice aforethought was present and that death occurred within a year and 1 day from the act, and that the chain of causation was actually intact. So in our next discussion, we are going to talk about the mens rea of murder. So if it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.